All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
So now, the floor is yours for the concluding statement. You have 45 minutes.
Thank you very much, Your Honors. We will use less than that 45 minutes. I believe, assure you. First, Mr. Cameron Chowdhury will go through a brief response to one of the issues raised by the defense, and then I will turn to your question and, and wrap up very briefly. Thank you.
Thank you very much. Please, sir.
Good afternoon, Your Honours. My name is Cameron Chowdhury, as has been stated, and I shall be addressing you on matters that were raised by the defence yesterday. In particular, I shall be addressing you and responding to the claim made by the defence that the court has before it the wrong man, and that Mr. Ali Abdul Rahman was never known by the alias Ali Kushayb. Your Honours are aware that the prosecution has already provided written submissions on this issue in filing 224 that was submitted on the 7th of December 2020, as well as in its pre-confirmation brief. As the evidence referred to in those submissions demonstrates, multiple sources establish that Mr. Ali Abdul Rahman and Ali Kushayb are the same person. This evidence is provided by persons who knew Mr. Ali Abdul Rahman before, during, and after the conflict. It is provided by his victims, as well as members of the armed forces of the government of Sudan who directly observed him during operations. The submissions made by the defence yesterday on this issue only serve to strengthen that evidence, and I shall address Your Honours on that. I shall also address you on the topic that the defence failed to provide an explanation for yesterday, and that is Mr. Ali Abdul Rahman's own words and conduct, which show that he himself uses the name Ali Kushayb. But I turn first to the defence submissions that support the prosecution's case. Yesterday, Your Honours heard Defence Counsel accept as true various facts on behalf of Mr. Ali Abdul Rahman. Between pages 64 and 66 of the real-time transcript, submissions made by the defence show that they agree with the prosecution in a number of respects. The defence agrees that Mr. Ali Abdul Rahman was a warrant officer in the Sudanese armed forces. They agree that he was the owner and operator of a pharmacy located in Gasilla. And they agree that he was a member of the Central Reserve Forces in 2005. These facts reinforce and corroborate the evidence provided by prosecution witnesses that are relied on to prove the link between the two names. For example, witness P117 states, and I quote, Ali Muhammad Ali Abdul Rahman had the nickname of Ali Kushayb. He also provides that Mr. Ali Abdul Rahman was a warrant officer in the Sudanese armed forces. Witnesses P112, P769, and P123 all knew Mr. Ali Abdul Rahman by both his legal name and his alias, Ali Kushayb. all three of those witnesses state that the person they knew by both of those names owned and operated a pharmacy located in Garcilla. Witness P769 states, and I quote, Ali Muhammad Ali Abdul Rahman is known as Ali Kushaib. And he provides that Mr. Ali Abdul Rahman was a member of the Central Reserve Forces. Witness P883 says the same thing. Several more witnesses are listed in the prosecution's filing, number 224. The sheer possibility that these witnesses are wrong, or that they are speaking about an entirely different person with both names, is implausible. Furthermore, the defense have not offered any explanation of why, since Mr. Ali Abdul Rahman surrendered to this court, no one has come forward to say that a terrible mistake of identity has been made. That is, not a single one of the victims who the defense have expressed their regret at disappointing have come forward to say that after waiting for justice for 18 years, regrettably, the wrong man is before this court. In addition, not a single member of the government of Sudan has come forward to say that either. I turn now to the next subject, and that is Mr. Ali Abdul Rahman's own words and conduct. Despite it being raised in the prosecution's written submissions, the defense appears to have chosen not to address Your Honours on the circumstances that has led him to appearing before this court today. This is not a case in which a suspect was arrested unwillingly. Your Honours, I see my learned friend rise.
Monsieur le Président, la règle que vous avez fixée pour la présentation sur le fond continue-t-elle de s'appliquer aux conclusions immédiates? Parce que sinon, je dois intervenir immédiatement.
Well, sir, I would tend to believe that the right thing is that you will challenge any when it's your turn
Je vous
to
remercie.
make your final statements.
Je vous remercie.
Please continue.
Your Honour, as I left off, this is not a case in which a suspect was arrested unwillingly. Rather, Mr. Ali Abdul Rahman voluntarily surrendered to this court, and upon an arrest warrant which clearly specified both names. In order to do so, he had to undertake a long and difficult journey from Sudan to the Central African Republic. The defense cannot now reasonably claim that the arrest warrant had nothing to do with Mr. Ali Abdul Rahman. Reflection on Mr. Ali Abdul Rahman's conduct during the surrender process itself serves as another basis from which Your Honours may conclude that he accepts that the name Ali Kushaib applies to himself. This is because at no time during the surrender process did he ever refute or take issue with the name Ali Kushaib. This includes when he was arrested and when the arrest warrant was read to him in Arabic by the Central African Republic authorities, or when he interacted with the registry of the court. On the contrary, what the evidence shows is that in arranging his voluntary surrender, Mr. Ali Abdul Rahman expressly used the name Ali Kushaib when speaking about himself. On the 20th of March 2020, several months in advance of his surrender, Mr. Ali Abdul Rahman provided an unsolicited video message to the office of the prosecutor. In the video, he can be heard to introduce himself in Arabic by both his legal name as well as the alias Ali Kushaib. The defense provides no explanation for this. I shall play you the video, and that's at ERN DAR OTP 0216-0119. Your Honours will be able to note from the video that at the start, Mr. Ali Abdul Rahman says in Arabic the following: Bismillah ar-Rahman ar-Rahim. Ana Ali Muhammad Ali Abd-Al Rahman al-Mulakkab Kushayb. This translates as, in the name of Allah, the Lord of mercy, the giver of mercy. I am Ali Muhammad Ali Abd-Al Rahman, and my nickname is Kushayb. I shall now play the video, and if I could just ask your assistants to see whether they're ready.
أنا علي محمد علي عبد الرحمن الملقب بكوشيب.
We could hear it, but not
بسم الله
so
الرحمن الرحيم.
Sorry, is it video or just a
It's a video clip of 9 seconds, Your Honour.
yeah, I don't see.
Would counsel kindly drag the video to the evidence?
Exactly, I
channel,
think it's
please?
on the
Thank you.
side. It's on the side. Yeah.
Is that it? Right.
بسم الله الرحمن الرحيم. أنا علي محمد علي عبد الرحمن الملقب بكوشيب.
Your Honours, Mr. Ali Abdul Rahman's words and conduct, and his express use of the name Ali Kushayb when speaking about himself, renders the claims that he makes now unreasonable. I conclude by briefly addressing you on the defence submissions that were raised yesterday and that relate to discrepancies in some of the evidence. Much was said yesterday in relation to discrepancies with respect to dates, Mr. Ali Abdul Rahman's age, his date of birth, or his progression through the Sudanese armed forces. But such discrepancies fail to undermine the multiple sources of evidence that have been put forward and which establish that Mr. Ali Abdul Rahman and Ali Kushayb are the same person. The prosecution submits that these discrepancies that the defence raised are neither problematic, they are not uncommon, nor are they unusual in trials that come before this court and which involve conflicts that may span several years. It is understood that evidence, as is the case in this instance, may be obtained several years after the events. Record keeping may not be precise. There is also a cultural dynamic. Dates and reference points differ amongst different communities. The defence itself acknowledged as much when it's made in its submissions yesterday and accepted that Mr. Ali Abdul Rahman's date of birth varied amongst documents it relied on. Mr. President, Your Honours, the court has the right person before it. This matter should proceed to trial, where Mr. Ali Abdul Rahman will have the opportunity to confront the many witnesses that say they know him by both names. This concludes my presentation.
Thank you very much, sir. Mr. Nikos.
Thank you very much, Your Honors. I'll try to first briefly address your question on the meaning of surrounding areas. Now, in regard to the crime bases in Delej and Mukjar, as Ms. Whitford spoke about, and Mr. Satchidanandan in relation to Mukhtar. The crime involved detained men, persons, being held inside the towns, and I'll put them together because it was very similar in both incidences, of Mukhtar and then shortly after Delej. These victims were placed on vehicles, taken outside the limits of the towns, Mukhtar and Delej, and then executed nearby in other locations. And as Ms. Whitford said, we cannot say the exact precise location of these execution sites. We're relying on the witness testimony of how many kilometers it was outside from the center of the town, etc. So there, we're talking about surrounding areas for the crimes in Mukhtar and Delej. There were several counts that occur within the crimes, torture, some of the murders, and other crimes within the actual towns, in the police stations, in the square, but other murders are carried out outside. In relation to Bindisi and Kadum in August 2003, this was one attack between about 15 and 16 August 2003, one course of conduct that we tried to make clear in the pre-confirmation brief and in our presentation. And now in the DCC, in the document containing the charges, in paragraph 5, we specify that other towns which were attacked at or around the same time are not charged. And we repeat this explanation as well. You can see in paragraph 149, and I'll make a note to a, it's redacted in the redacted version of the pre-confirmation brief, but in the unredacted version, there's relevant information in footnote 631 as well. Now, as these crimes are occurring, as the evidence shows from the witnesses, and as Ms. Sims discussed, and it's set out in our brief, many of the citizens, the villagers, fled the towns of Kadum and Bindisi. And during this attack, crimes were committed along the roads and in the fields nearby outside of these towns. So that is, in essence, what we are discussing. At this time, victims of this type of crime in Kadum and Bindisi would not have had GPS device, anything like that that would provide an exact, precise location of how many meters or kilometers outside of the village proper, the village itself. So that is what we are referring to. I hope that is helpful. And the jurisprudence I would point you to quickly is in the Netaganda case, the reparations order of 8 March 2021 at paragraph 107. And in that same case, in the decision on the updated document containing the charges, 6 February 2015, at paragraph 74, where the chambers discuss that all the crimes may not have occurred in the actual location mentioned, but somewhere nearby. That would be my explanation, Your Honor, but I'm happy if you have a further question to try to address it.
Please continue with your statement.
Okay. Thank you. Now to conclude, as I said very briefly, what we have done in this hearing is to try to set out as clearly as possible the line of reasoning that shows that Mr. Al-Rabdan Ali Kushaib is responsible for all the counts in the document containing the charges. We've shown that in our presentations over the last days and as set out in our DCC and in our PCB. Nothing we've heard from the defense nothing changes the fact that we have met the substantial grounds standard. The name issue, Cameron Chowdhury has discussed, and the defense there seems to be, well, it's not me, but if it is me, I'm relying on an expert report that was deliberately designed to focus on a hypothetical conflict in a hypothetical country or region with hypothetical combatants, a hypothetical defendant with a hypothetical training level. And there was the purposeful decision not to provide the military expert with information surrounding this case. So all of the issues, I would say, Your Honors, raised by the defense point to one thing, that it's time for a trial on this case. These are all potential defenses we have heard which can be raised at trial. The confirmation standard is met, should have a trial to sort out all of these issues, and there can be cross-examination on whether there are earrings and all of these matters. So we request, Your Honors, that all of the counts be bound over for trial. And just finally, I'll respond to one point raised by the various representatives for the victims, because you've raised it. We will 100% continue to investigate. We are guided by the evidence and the law and our burdens that we must meet. And when and if we meet those burdens that will sustain additional charges, we will present them to the chamber, and it will be up to the chamber to decide. Thank you, Your Honors.
Thank you very much, Mr. Prosecutor.